Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday, is Alex Ooley of the Forge of Freedom podcast. Alex is an attorney in Indiana, and we're going to be talking about several things that have to do with legal terms and terminologies, although I should start, as we get started, two things. Number one, I want to say we're not giving out legal advice. Alex can't do that anywhere other than Indiana, and if you need legal advice and you're in Indiana, get a hold of him. Yeah, that's what he does for a living. So anywhere else, this is just for education and entertainment only, not legal advice. Second thing is, if you're watching us on the Polite Society Podcast Facebook or YouTube feed, you can comment on those videos. We'll get your comments up. Anywhere else, go to Twitter, tweet with the hashtag #TheBullet. As we get started, Alex, you just got back from Florida, and you're in southern Indiana. What's the weather doing down there?
Well, it's not as warm as it is in Florida. It was 70s, 80s every day in Florida, and I came back to the reality of cold weather in Indiana. But I've been back about a week, and I'm pretty well adjusted now, so I can't complain too much.
Yeah, we're supposed to get snow tonight, enough that they've issued a snow alert in my city, even though there's not a cloud in the sky yet. And after the snow comes through, we're supposed to see a drop where we're getting highs of 3 degrees, single-digit highs, which is, it's South Dakota. You get that every winter. You live with it, but it's still a shock to the system every time. So let's get started. And you've been mentioned several times in our conversations as we've been going through this week, Alex, mainly because last week a judge in Illinois granted a temporary restraining order against the state for 850 named people who sued in the state, and that was in Effingham County, Illinois. The question has been, when a judge issues a temporary restraining order, in this case, the news stories look like it only affects the 850 people that filed lawsuit in Effingham County, or does that take place for that entire county, or how does that work?
Yeah, so my understanding is that this case actually involves plaintiffs from multiple counties, the cases simply being heard in Effingham County. And the temporary restraining order, only applies to the plaintiffs in this case. And in fact, if you look at the order, it says this order is binding upon all the parties to this action, including all of their officers, agents, employees, and attorneys. So this is not a broadly or widely applicable order. It wouldn't apply to the entire state, or even the entirety of Effingham County or the surrounding counties, just to the parties to the suit.
Okay, that's from what I gathered about what was written about that judgment. That's kind of what I gathered, but there were enough people on the show that said, I just don't know if it works that way, that I figured I would bring it up.
Yeah, and I will point out, though, that even though it's not a widely applicable order, there are, as you said, 800 and some odd plaintiffs, so that's quite a few, but nevertheless, I think this order is a good sign in Illinois. The judge doesn't quite get everything right in his order, but he says a lot of good things. And I think that the temporary restraining order is largely based on this single subject rule in Illinois, and that this legislation it addressed more than just firearms, and therefore was in violation of the single subject rule in Illinois. But the judge also talked about equal protection problems and the fundamental right that we enjoy to self-defense, and how this law clearly infringes on that. He did mention that the restrictions on the Second Amendment are subject to strict scrutiny, which is not true, as we know from the Bruin decision, that strict scrutiny is one of the balancing tests that was clearly abrogated by the Supreme Court, and that we simply look to the text, history, and tradition of the Second Amendment. But nevertheless, it's a good sign in Illinois, and I think more broadly, I think we're seeing these sorts of decisions come out nationwide.
Well, and I do a news search every morning for news in the Second Amendment arena, and I cast a pretty wide net, and almost half of the stories that are coming back this week are about Illinois. There's been Second Amendment Foundation's got 3 lawsuits in federal court right now against Illinois. I know GOA has one. I know FPC is with us on 2 of ours, and I think they have their own. There are so many lawsuits active against Illinois right now that I seen a story today, this off cities29.929.com, that the state is looking to combine all these lawsuits into one federal lawsuit. Would that be good, or would that be bad, or would it be indifferent for the organizations that are filing these lawsuits?
I don't know which lawsuits exactly are being proposed to be consolidated, but generally consolidation happens where for convenience and to economize, so that you're not litigating the same issues in different courts in the same jurisdiction. So generally, I would say that it's a good thing, but I can't say for certain without knowing more specifically which suits are trying to be consolidated. But I think that that's generally a good thing.
Okay, so it's unusual. Illinois wants to do something that may be good for us. That's very unusual.
Well, they also don't want to be fighting gun rights organizations on the same issue from various different attack points. So it helps them to some degree as well, but it also allows the gun rights organizations to sort of join forces in some ways as well. So it can work hand in hand and be good for both sides. But also, I think Illinois has got a tough position to take in light of the Bruin decision. This Protect Illinois Communities Act, while like a lot of government legislation, it sounds harmless. I mean, it clearly is in violation of Bruin, and I think will ultimately fail in the courts.
Yeah, I totally agree with you. There's for so many reasons, I think this is gonna fail in the courts. Not just Second Amendment, but there's a lot more than that. I want to kind of shift gears on you. I'm going to stay in the legal arena. The one I found this morning off of AmmoLand. I'm just going to read a couple paragraphs out of this. On June 14th, 2022, Jesus Perez Garcia was arrested as a passenger in a car crossing the Mexican border into the United States. A significant quantity of illegal drugs was found in the vehicle's bumper. Jesus claimed he did not know of the drugs being there. The driver of the vehicle, Antonio, supported Jesus' claim, saying he took full responsibility for the drugs in the vehicle. Jesus admitted the driver told him he was going to get drugs, but he thought the drugs would be for personal use in Mexico. Jesus has no criminal history. He worked in California as a security guard and is a U.S. citizen. He pled not guilty and was released on bond on June 30th. Conditions of his bail were not disclosed at the hearing. Going on down in the story, turns out his Second Amendment rights are gone, and he's suing now, saying, look, I have not been convicted of anything. I have no felonies on my record. How can this be that I do not have Second Amendment rights? By the way, as an armed guard, you kind of have to have your Second Amendment rights to have a livelihood. Alex, I kind of want your take here. My understanding is, of course, if you've got a felony, you lose your Second Amendment rights, but just to be accused of one and you lose your Second Amendment rights?
Yeah, I've always hated these sorts of bond provisions, these pretrial release provisions. I come across these in Indiana from time to time, and there are standard conditions of bond in some places, and I think they clearly are infringements. Like you said, without even a conviction, they're taking away someone's right to keep and bear arms. And I don't think that a felony conviction should necessarily disqualify someone from having the right to keep and bear arms. And that's also being litigated in the federal courts at this point, too, with respect to nonviolent felonies. So even where somebody is convicted of a felony, it shouldn't necessarily deprive them of the right to keep and bear arms. And I think this is just an egregious deprivation of fundamental liberties that we have as natural rights and that are protected by the Second Amendment.
Well, and not only that, just thinking at it from a practical standpoint, he was released in June on bond. And how long is it going to take for this thing to grind through court? So much for a fair and speedy trial. He could be a year waiting for this thing, or possibly longer waiting for this thing to finally get through the court system so he can get his Second Amendment rights fully back.
Yeah, that's right. The wheels of justice turn slowly, and it always reminds me. I'm reminded of this frequently. The saying that justice delayed is justice denied, and I think that's clearly what's going on here. And here, what's so bad about it is the facts that he was the passenger, the driver claimed responsibility. So, I mean, it's a stretch to say that there's probable cause to even charge this guy, let alone take it to trial and deprive him of his rights in the meantime. So, I think, I hope he can find some relief in the courts, but I think he probably will. But it's going to be a long time before he gets there. Well,
and the federal court for there, of course, is the Ninth Circuit, which has not historically been known as the most gun-friendly federal district court. There's been some movement there, but this guy needs some luck.
Yeah. But again, if you look at the text history and tradition, what history is there to support the deprivation of someone who has not been convicted of any crime of their fundamental rights? And I think that the California government is going to be hard-pressed to come up with history to support this sort of practice.
Woods from the YouTube side has a comment, and he wants to know, did he agree to that as a provision of the bond? It was written in there. I don't know if he was expressly made aware of it at the time, but the story says that it was part of the bond when he was released. Knowing California, that wouldn't shock me, but it's playing dirty pool, if you ask me.
Yeah, typically somebody who is released on bond signs conditions of release when they bond out. But when you're faced with staying in jail and waiting to litigate the conditions of your bond, or getting out and losing your fundamental right to keep and bear arms, I think that's a choice that you shouldn't be faced with. And I think that's part of the problem here.
All right. Next story I've got, Alex. This is off of KTEN.com. There are several several county sheriffs in Texoma, say they are standing up for the Second Amendment after a new ruling from the Department of Justice requiring gun owners who have stabilizing braces attached to a pistol to either register the device or remove it within 120 days. The sheriffs are saying, at least in Texoma County, we're not going to enforce this. That's great. However, county sheriffs are not the only law enforcement agencies. Matter of fact, they rarely are. There's also city, there's state, and Lord knows there are some federal. This doesn't nullify. This is what I want to get across. If your sheriff says my department is not going to enforce this, that doesn't make it legal. It doesn't mean you won't get caught. It doesn't mean you won't get in legal trouble. You very well could if you don't comply with the law. That's why it's so hard for us to, it's important for us to fight these things before they become law. And if they do become regulations, which this is, it's not a law, it's a regulation. If they do become regulation, we sue and get it knocked down before you go shouldering your pistol, your AR pistol with the pistol brace on it, at least in front of law enforcement. What's your take, Alex?
Yeah, you're exactly right, Paul. I mean, I'm glad that there are sheriffs, not just in Texoma, but we saw a similar situation in Illinois recently, who are standing up to unconstitutional laws and saying that they're not going to engage in the enforcement of these sorts of unconstitutional laws, which I think is consistent with their oath to the Constitution. But you're right that they're not the only law enforcement out there. There are state and local law enforcement other than the sheriff's department. And those agencies could very well be tasked with enforcing these sorts of unconstitutional provisions. In fact, in my experience, state police are less reluctant to enforce unconstitutional provisions than sheriffs, the ones who are closer to the voters, because state police are not elected. And at least in Indiana, the superintendent is selected by the governor, the superintendent of the state police, that is. So they're not accountable to the voters, at least directly. They are through the election of the governor indirectly, but the sheriff is accountable to the voters, and they're kind of the last line of defense in that regard.
Yeah, it's unfortunate this happens. I mean, well, no, it's both fortunate and unfortunate, because it leaves citizens in these jurisdictions kind of in a limbo. Yeah, I don't know, the county sheriff isn't going to do anything to me, but what if a state policeman stops me? What if the city police have contact with me? So yeah, it's good on the sheriffs, but I still wouldn't I wouldn't blatantly defy the law is where I'm standing.
Certainly. And of course, federal law enforcement could still come into play. Obviously, there aren't nearly as many federal law enforcement as there are state and local, but and federal law enforcement wouldn't have the manpower to enforce these regulations nationwide. But nevertheless, they could, and I don't want any of our listeners to be the guinea pig in that regard.
Yeah, exactly. Well, and here's the kind of catch-22. In order to sue, you have to have been damaged, and so there are lawsuits. SAF has got one in federal court against this pistol brace ban, and a lot of other things against the ATF right now. But it's kind of you have to be injured in order to sue the government, and even then, I remember when I was in college, I was taking some legal courses, and there's a term that I still to this day remember, which shocks me: noblesse oblige, which translated means the king can do no wrong. Generally, it means you need the government's permission to sue the government. And it always burns me that has made it to the American legal system. But I don't know. I guess I can understand it to a point. It just, it makes it harder to make the government accountable.
Certainly. There are lots of impediments to holding the government accountable, depending on the circumstance. But obviously, like you said, you have to be harmed, or there has to be a likelihood that you would be harmed. You can't be some just person who doesn't like the law but doesn't carry a firearm, is not likely to carry a firearm. You have to be someone who is either actually damaged or likely to be harmed as a result of the law. So you have to have standing to bring the lawsuit. So that's one of the impediments there is to challenging a law. But there are certainly many others, including qualified immunity, absolute immunity, etc.
All right, let's go ahead and go to our next story, and this one off registercitizen.com. Just days after declaring his intent to crack down on ghost guns and open carry, Governor Ned Lamont on Thursday announced a plan to reinforce the state's longstanding ban on military-style weapons, including closing the loophole for weapons manufactured before 1994. Basically, what Lamont wants to do is to ban. There's already a ban on assault weapons, and then that's Connecticut, for those who don't know where Lamont's governor. There's already a ban on assault weapons in Connecticut, grandfathered in as anything manufactured before 1994. Now he's saying, I don't care if it was made before 1994, you got to get rid of it. You cannot sell it. It's got to just go away. You can't sell it in state. It's got to go away. And I know this is not directly legal. And I try, usually when you're on, I try to keep things towards the legal side. But what burns me about this one is there's absolutely no evidence that these are any more dangerous than any other firearm, and yet they're going after them because of the bad image.
Yeah, I think that's sort of a tactic of lots of politicians, right? It's to make certain scary sounding firearms the poster child for all the ails in society, all the ailments in society, and they're almost never used in crime, or very rarely used in crimes. And so I think this is clearly just a tactic by the governor to go after these so-called ghost guns. And it's the same sort of tactic we've seen with so-called high-capacity magazines and assault weapons and the like. So I think there's clearly no factual basis to support his assertions or reasons why we should try to outlaw these sorts of items.
Okay, last story I've got today. This is off NRAILA.org, and this is a story that New Hampshire is trying to get two resolutions through. H.R. 8 urges Congress to pass an assault weapons ban. And, it's not, how do I put this? It's a drop in that one's just a drop in the bucket. They can urge Congress to do anything. They can urge Congress to negate the entirety of the Constitution and install a kingdom. They can urge Congress to do whatever they want. Congress is just going to go tell them to pound sand. The other one, House Bill 158, bans ammunition designed and intended to penetrate armor-piercing or ballistic vests. That one, that's already against federal law. Seems like New Hampshire just wants to waste its time, man.
Yeah, I think these are just political statements, more or less. Kind of like some of the recent proposed legislation by Republicans that, in Congress that has no chance of passing, but nevertheless is a statement to their voters. And I think this is largely what's going on in New Hampshire. It's just grandstanding. It has no chance of success. It's just a statement to the voters.
Sure, absolutely. Well, and one that I talked about, I want to say it was Saturday on the weekend show, last week. It's got zero chance of going through, but it looks great, is the Abolish the ATF Act that's going through that's in the House right now. It's been assigned to committee, but that's it. I think that's actually got a decent chance of passing the House. It's got no chance of going any further.
Yeah, that's exactly the legislation I had in mind. It's a shame that it wasn't proposed when Congress, or when the Republicans had control of both houses of Congress and Donald Trump as president. So
yeah,
that would have been a good time to propose it, not a time when it's got zero chance of passing.
Well, and let's hope everything works wonderfully in 2 years and it swings back to where there's a freedom-loving House, a freedom-loving Senate, and a freedom-loving president, and we can get that and concealed carry reciprocity. I'd love to see those two both go through, but it seems they always get introduced when they have zero chance of going through.
Yeah.
So, hey, and I want to get John's comment up here on our way up before we start wrapping things up. I knew this, but I didn't remember it. John over on the Facebook side says Sig Sauer is in New Hampshire. They are, well, for now they are. Colt left New York. There's been many firearms companies that have left restrictive states and retreated to freedom-loving states. Wyoming, I know, got some firearms manufacturers. Texas has gotten some. Georgia has gotten some. I'm hopeful that continues, because if you don't like the Second Amendment, you shouldn't benefit from Second Amendment companies being in your state and paying taxes.
Right. I mean, I'm sure that the burden of moving your manufacturing facilities is tremendous, but I'm always encouraged when I see companies move to more freedom-loving states, because that tells me that the company's got a better chance of survival in the long run.
Yeah, absolutely. All right, man, we are just about to the bottom of the hour. If we would, I've been putting you, for people who have got either watching us on a bigger screen or have got very sharp eyes, notice when I put Alex up solo, there is a logo up to his top right, and I've got Forge of Freedom podcast underneath his name. Alex, would you tell everybody about Forge of Freedom a little bit and where they can find it?
Sure. So, like you mentioned at the beginning of the show, I'm an attorney. I'm also a firearms instructor. But my passion isn't just the law or firearms. My passion more generally, more broadly, is freedom. And I'm always reminded of the speech by Ronald Reagan where he said that freedom is not passed down through the bloodstream. It's something that you have to win generation after generation and fight for generation after generation. And I think that people need to hear the message of freedom and personal responsibility, so that we can preserve freedom for future generations. I think we a lot of times take the freedoms we have for granted. I was thinking, obviously this is the bullet, and we talk a lot about the Second Amendment. That's just one of the freedoms that we have and enjoy, a very important one, and I think indispensable to a free society. But if you're interested in other aspects of freedom, tune in to Forge of Freedom. It's on YouTube. It's on Rumble. It's also on most of your podcast streaming sources.
Very cool. On my end, I want to say thanks for tuning in this week. Thanks for everybody that's commented. And even if I haven't got your comments on the air, thank you for commenting. We will be back tomorrow for the weekend edition of The Bullet. Tony Simon. Oh, let me get because my memory is not that great. Let me get my booking calendar up here. Tony Simon is going to be back tomorrow. Rob Beckman and Charles Heller are going to be my commentators for the weekend edition of The Bullet that comes up tomorrow at noon Central Time. Please do come join me for that. And that's going to do it for us today. Thanks, everybody, for watching, and we'll see you next time.